it's more, or the defendant's perspective, it's more like a bludgeon. Basically I have no choice but to plead guilty because otherwise I'm looking at this mandatory minimum. So it certainly tips the scales of justice a little bit, one might argue. And it'd be interesting to see if we can come up with data to confirm or refute that. Professor Osler, would you mind telling us your vision for the legal analysis and purpose subcommittee?
Yeah, well, later in this meeting, I'm going to be talking some about the history of mandatory minimums, and we've had some discussion about that so far. Right now, I have a student at St. Thomas who's working on compiling a survey of states that have done reform in this area and some of the history of mandatory minimums in some of those other states. I can tell you preliminarily from what we've seen, there's not a lot of examples in recent years that we're finding of mandatory minimums cutting back. In other words, reform towards reduction in mandatory minimums, but there are some significant examples historically we'll be talking about. I think as we go forward, probably we'll want to communicate with people in other states too about their experiences.
All right, thank you for that. And finally, we have Assistant Commissioner Mitchell. Kelly, why don't you tell us about your vision for the stakeholder outreach subcommittee? Stakeholder input, I guess we're calling it.
Thanks.
I guess it's two sides of the same coin, right? Outreach input.
Not really. So I'm glad that you said that because I think there is a difference. Oops, we lost some folks. Okay. Sorry, we just lost a couple people. So a little weird.
I just had
Nate, Nate, I think you have to mute while we're talking in the room because we're getting feedback here. So, all right. So for the stakeholder input session, the law requires stakeholder input, and as we talked about last time, we talked about different formats and what information could potentially be gathered from people. We talked mostly about the format, and I think I heard from the committee that probably pursuing a process where we could do interviews with the affected people would be the most effective way to get more candid feedback. So what I'd like to do is put out a solicitation. We have some funding for this purpose, so put out a solicitation to some organizations that could help us with that. So I would envision the subcommittee helping to draft that solicitation and then helping to review any actual responses to that we received and making recommendations to this committee about who we should go with. And then I think I would envision that group really being the one to then present the results of that input. So I think that the work of this subcommittee is primarily on the front end. We'd be figuring out really who are we targeting, what sorts of information are we looking to glean, what sorts of questions are we looking for this for the organization to be asking, and what are our goals with that sort of feedback. So that's what I'm thinking.
Thanks. Yeah, and some of the challenges there, just making, it's really the low-hanging fruit are big metro areas, but then you got to make sure it's a statewide thing and you're getting a good balance, and that can get expensive quickly. So it's a tough balance. Okay, well, thank you, subcommittee chairs. I appreciate that. I hope that gave you some idea of which subcommittees you want to be on. I will tell you that because of the sub-quorum requirement for each subcommittee, you may not get your first choice. So we are going to have you sort of do a ranked choice voting and divide you up among the subcommittees that way. But that'll be something I think we can do between the meetings. All right. So last time we talked about, we sort of were given a catalog of all the mandatory minimum sentences, and it wasn't put to a vote or anything, but in terms of the scope of the task force, the sense that I got was that there was an interest in sort of focusing the task force on the more commonly used mandatory minimum sentences, and those were the 6 and 9/11. I mean, even breaking them up into ineligible people possessing firearms and other 6 and 9/11, they're still the two most common categories in terms of number of cases each year that fall under the rubric of the mandatory minimum. So I think those two by themselves made up about almost 3/4 of the cases that we saw in 2023. And that was followed, I believe, by the failure to register as a predatory offender mandatory minimums, and then by the drug mandatory minimums. And then finally, we had a much smaller slice of other, which, although small in terms of the number of cases, it should be emphasized, includes some pretty significant mandatory minimums, to include all our life and life without the possibility of release mandatory minimums, which obviously is huge on a personal impact, on a case-by-case basis, but definitely smaller in terms of the number of cases each year. Also, we did point out, I guess maybe this is only something that I is interesting in my mind, but the life without possibility of release for premeditated murder was adopted 20 years ago, which means that if those people had gotten life rather than life without the possibility of release, they wouldn't be getting their first look for parole for another 10 years. So I guess in that sense, there's less time sensitivity to that, but I could be wrong. So my I guess my question is, does anybody, and I think it was Assistant Commissioner Mitchell who sort of voiced an opinion at the last meeting that really it makes sense to focus on those major areas, the 6 and 9/11s, the failure to register as a predatory offender, and I think you said the drugs too. Is that right, Kelly?
Yeah, it was all of the ones that you had on your graph, all of them
Other than
except the other category.
Yeah. And so I think we kind of went by that pretty quickly at the last meeting. So I just want to give people a chance to discuss that more. Is that the consensus of the group, that we should be looking at those three categories, basically, assuming you're grouping? There's really a 6 and 9/11 sort of has its own mandatory minimum structure for ineligible people possessing firearms, and then there's another. So it's got that structure, and then it's got the structure of, if you commit one of the listed offenses while using a dangerous weapon or in possession of a firearm, then you get all these other mandatory minimums. But it's almost like two separate mandatory minimum schemes. So that's why I broke those up. So let's call those two. So those two in 6 and 9/11, and then you've got the mandatory minimums for failure to register as a predatory offender, and then you've got these mandatory minimums for first and second degree controlled substance crime. Is that the scope? Is that the consensus, that that's what the scope of this task force should be, or is that something we should keep open, or do people feel like the scope should be broadened beyond that? Yes, Ashley.
Can you hear me?
Yes.
Okay. How about now?
We can hear you. We're getting the same feedback you might be getting. Now we can't. Now you're muted.
Don, maybe you can mute the room while Ashley's talking. That might help.
Yeah. Does anybody else, when you have tech issues? All right. I apologize. I think this is better. Can you hear me? Okay. My brain kind of shuts down when I have tech issues and I can't troubleshoot very well. Anyways, I know at the last meeting, I can't remember who brought it up, but I do agree with having the like exploration of the top three like crimes with mandatory minimums, but I wonder if we could have like an additional group that does look at like mandatory minimums in general and if they like what purpose they're serving and if they're just so yeah, I guess I was wondering if maybe we could do it that way, like have those subcommittees and then have kind of a larger like looking at mandatory minimums as a whole, which again, I'm not going to take credit for it because I think someone else mentioned it, but I thought it was a good point.
Yeah, and I think I think that's kind of I would put that sort of conceptually under Professor Osler's umbrella, like just looking in general at why do we have mandatory minimums? What is the purpose? So it's and he will be talking about some of that in a bit, but like for example, the presentation I'm about to do. Well, I guess I'll wait till I actually do that presentation. Any other comments? Thank you for that, Ashley. Any other comments about scope? Yes. Sorry, I can't see who's raising his hand.
John Donovan.
Okay.
And I would agree with the scope that we've all been discussing and also the purpose. I guess I would also maybe vote against wanting to look at life sentences. I hate life sentences, but I also, I guess, don't consider them necessarily mandatory minimum sentences. I always think of mandatory minimum sentences as setting a floor, but they can always be up. Felon in possession can be more than 60 months. That's just setting the floor, whereas a life sentence seems to be more just a mandatory sentence. It's setting the floor and the ceiling. So I just don't know if it necessarily falls in the purview. Again, I'm not saying I'm a fan of them, but if we're looking for ways to sort of narrow the focus, I always just thought of that as more of a mandatory rather than mandatory minimum. So for what it's worth.
Yeah, I mean, I suppose it's, well, I mean, technically it is a mandatory minimum. You're right. It also is a mandatory maximum. It's, there's really not a lot of work to be done if you're sentencing somebody for premeditated murder in Minnesota. It's, there's only one lawful sentence. So, that is correct.
Seal out.
So just to speak to that briefly, is
Yes.
yeah, there we don't have it in Minnesota, but there are a lot of systems, including the federal system, where in the code that establishes mandatory minimums, there's some that have floor and ceiling, and then there's life. Until the First Step Act, for example, in 21 USC 841B, which covered narcotics crimes, you had a 5-year mandatory minimum, 10-year mandatory minimum, and then a life mandatory minimum, and they were all in the same code section.
Yeah. Well, and I think that's one of the interesting things about life and life without the possibility of release is that they are, there's only one lawful sentence and therefore only one appropriate sentence, which means, by definition, the legislature saying one size fits all. This is, everybody who fits in this category is either so blameworthy or so dangerous that, they must be, they must never get out. But you know, I think it's probably true that the legislature may not have had this in mind. It certainly wasn't an example offense, you know, that they listed. But it's also true that we have recommendations at the end, and maybe one of the recommendations is to study some of these things that aren't going to be within scope. You know, maybe there should be some other entity that looks at life, and life sentences, and sort of how that's evolved over time. Any other discussion on scope? So, I mean, it does seem like Assistant Commissioner Mitchell's suggestion is bearing out to be sort of the consensus of the task force based on the discussion so far. Okay. All right. Well, I'm going to share, if I can share. Let me see if I have the proper. Looks like I do. I'm attempting to share a PowerPoint. Can you see the PowerPoint, or do you see like the guts behind the PowerPoint? You see the
We
PowerPoint?
can see the PowerPoint.
Excellent. Okay, so this is my attempt to describe the history of 611's mandatory minimum penalties from 1974 to present. And actually, I'll talk a little bit about before 1974. But I just want to give a caveat here, though. This is not going to be any kind of explanation into you know, sort of the legislative history or what the times were, what people were thinking, that sort of thing. I didn't do any of that sort of analysis. This is just really looking at the text and how the text changed. And I think just even that very simplistic analysis, there's a lot of observations that can be made. So I will be making editorial observations along the way. Those are in the little cloud balloons on each slide, but yeah, hopefully it'll be useful. And then at the end, I'm going to present a slide on sort of what were some issues that I saw as a result of this. You know, what were some issues for further research or further discussion or further exploration. And I'd encourage you, as we're going through each slide, to sort of make notes yourself of what issues you think are brought up, if any, by a particular choice that the legislature made over time. Because from 1974 to the present, the legislature made a number of different choices regarding mandatory minimum sentences. And in some ways, I think their choices, you know, I sort of maybe regressed in terms of rationality or clarity of purpose. So let's take a look first of all, though, at before 1974. So we're going to start at the beginning of the criminal code in 1963. That's when the criminal code was created, and it's 611 simply read: all commitments to the Commissioner of Corrections for imprisonment of the defendant are without minimum terms, except when sentenced is to life imprisonment as required by law. So that language is still there. I just always find that a little bit amusing that is what 611 used to be. It was basically saying mandatory minimums. What mandatory minimums? There are no mandatory minimums except for life. But then and ironically now we view 611 as the mandatory minimum statute. In 1969, an exception was created. So this was the first mandatory minimum under 611. It was a 3-year mandatory minimum sentence for possessing a firearm when committing an intentional felony, and later expanded to include discharging explosives. So possessing a firearm, committing an intentional felony, 3-year mandatory minimum sentence. Pretty simple. And then 1974, the legislature created today's basic structure. So the reason I'm starting with 1974 in this presentation is because the structure that was in place in 1974 is basically the structure that it remains in place today. That is that there's a list of crimes And if the defendant violates one of the listed crimes, and in doing so, the defendant has some sort of weapon use or possession, then that will result in a mandatory minimum penalty. So listed crime with a weapon, mandatory minimum. So you recall that in 1969, there was no crime list. It was simply an intentional felony. So between 1969 to 1974, they changed that from any intentional felony to these listed crimes. So that begs the question: what's the purpose of the offense list? Again, didn't do any legislative history research, but just kind of looking at the law. And actually, I looked at today's law. What it never explicitly named the list in 6911, but in a couple of other statutes that use the 6911 offense list, currently found in subdivision 9, by the way, they describe the list as a crime of violence list. Just in one case, it's almost in passing in 609.495, but a little more directly in 588.20. So, and maybe that's what the legislature was getting at, that this is supposed to be a crime of violence list. And if you commit a crime of violence and there's a firearm or a dangerous weapon involved, that's when there should be a mandatory minimum. Like last time, I'm going to refer to mandatory minimums even if there's a waiver options, which, doesn't really comport with the ordinary use of the term mandatory. But I'm going to use the term mandatory minimum anyway, because that's normally the legislative parlance. Waivable means the legislature has provided a waiver option. There may be particular requirements. I'm really not getting into the process for waiver in this presentation. But in current day, it means that the judge has to find substantial and compelling reasons to deviate from the mandatory minimum. And in this slide, when I say dangerous weapon, that's shorthand for a dangerous weapon other than a firearm. So, and under the definition of dangerous weapons, you have firearms, which are per se dangerous weapons. And then you have something that's designed as a weapon and capable of producing death or great bodily harm. So this might be something like a sword. Sword is designed as a weapon. Recently, the Supreme Court held that a machete was designed as a weapon. I have a machete hanging in my office. I can tell you, I got it from Panama, and I can tell you in Panama, they don't consider machetes to be weapons. They consider machetes to be tools. Nevertheless, in Minnesota, machete has now been deemed by the Supreme Court to be something that was designed as a weapon, much like a sword. I suppose brass knuckles might fall into this, perhaps a tactical pen, things that are designed as weapons. But this is not where we normally see dangerous weapons. So at least not in my experience. We really see more dangerous weapons in the second category. That's anything else that is used or is intended to be used is calculated or likely to produce death or great bodily harm. So let's say a kitchen knife. A kitchen knife is not designed as a weapon. It's designed to cut out food. But if I take that kitchen knife and I use it in a way that's calculated or likely to produce death or great bodily harm, say by slashing at somebody, then I've converted that kitchen knife to a dangerous weapon. Likewise, I could convert a baseball bat to a dangerous weapon by the way that I use it or intend to use it. I could convert, a lamppost. Anything just about could be converted to dangerous weapons, and that's the most common, at least in my experience. That's the most common use of dangerous weapon. The reason I bring this up is because there's some language in the, I'd say there's problematic language in the current waiver, or I should say non-waiver provision, that says that a mandatory minimum is is non-waivable if the defendant had previously been convicted of an offense, a listed offense, while possessing a dangerous weapon. And if you think of a dangerous weapon other than a firearm, like say a pocket knife, which is not designed as a weapon, it's something that you can use for non-assaultive purposes. But if you have a pocket knife in your pocket, does that qualify as an offense that you committed while possessing a dangerous weapon? It's much harder to say, and it's much easier to use the standard that's actually in the main mandatory minimum statute, which is using a dangerous weapon, because it's really as it is used that it becomes a dangerous weapon. You see what I'm saying? So a kitchen knife used to chop up potatoes is not a dangerous weapon, but it is if it's used to assault somebody else in the kitchen. So let's begin. So we have 1974, the original version of this crime, committing a listed crime while using a dangerous weapon or possessing a firearm. So 3-year mandatory minimum, and it is waivable, provided that there's no prior conviction. And they have the list of prior convictions. So and we have the original offense list, which really isn't that different. We'll go through some differences between the original offense list, but the 1974 version isn't terribly different from our current offense list. I mean, considering the amount of time that's passed, it's surprisingly similar. So a few things that I observe about this: there's one simple mandatory minimum. The other thing is that firearm possession is equated to other dangerous weapon use. And there's something attractive about this to me, because it does seem like, firearms are always dangerous weapons, right? Inherently dangerous weapons, defined as dangerous weapons. So the mere possession of a firearm seems like it sort of perhaps creates some instability in the situation, particularly if you're possessing a firearm while committing one of these crimes. That isn't true if you have, say, a knife in your pocket, right? Because like we said, the knife may or may not be a dangerous weapon until it's pulled out and used, whereas a firearm is always going to be a dangerous weapon, even in possession. So there's something attractive to me about this, and this is really subjective, but something attractive to me about the legislature's choice here in 1974 to equate using a dangerous weapon versus merely possessing a firearm. How it's used is different, but also the level of firearm is different, and the two kind of cancel each other out, and they're both similar in terms of dangerousness. The other thing to note here is that the waivability depends on prior record, and this is something that we don't see for a long time. So after 1975, that's going to go away, and it will not come back until 1994. So it's going to take a 20-year hiatus, and maybe in the 20-year hiatus, you're going to see where they're all waivable, and you're going to see where they're non-waivable. And maybe the lesson there is that it's not stable if you have all waivable or non-waivable. Maybe the more politically stable scenario is to make it waivable depending on the prior record, because once that's reinstated in 1994, it never goes away. So there's sort of this conditional waivability depending on prior record. All right, so let's move on to 1975. So in 1975, there's a shorter mandatory minimum. So the 3 years remains, but it's shortened if it's first time. So basically, somebody gets a break if it's first time. The trade-off, though, is the waiver provision is taken away. So first time users of dangerous weapon while committing an offense or possessing a firearm while committing an offense will get a break, but there's no waiver provided. Now, I got to be honest. I haven't looked at the case law back then. I don't know whether the lack of a waiver provision meant that it was really a hard mandatory minimum, but that's certainly the appellate courts. That's certainly the position of the appellate courts today. If there's no waiver provision and the statute says shall be sentenced, then the defendant shall be sentenced. It is a hard mandatory minimum, at least if the case gets up to the Court of Appeals. If anybody has any questions or comments at any point during the presentation, I'd be happy to interrupt my presentation to take them, but I will say I can't see anybody at this point the way my setup is, so you're going to have to audibly interrupt me. All right, so moving on to 1979. Now, the 1979 change it may seem a little bit lawyer nerdy because there were two sort of lawyer nerdy changes that were made in 1979. One is, in addition to defendants possessing a firearm or using a dangerous weapon while committing one of the listed offenses, accomplices are included as well. And the offense list is expanded to include attempts. So that you know, to put it in plain language, though, what that means is it doesn't matter which accomplice is holding the weapon. So if there's a group of people and only one of them is holding the weapon, everybody's and they're all accomplices together. Everybody's is as liable for holding the weapon as the person who actually was holding the weapon. So it doesn't matter which person in the group is holding the weapon. It doesn't matter whether the other people in the group knew that somebody was holding the weapon. Every accomplice then becomes liable for holding the weapon. And it also doesn't matter whether the crime was completed or not. So if it's merely attempted, but it's unsuccessful, it doesn't matter. The mandatory minimum still applies, and it applies in full. Unlike the general rule on attempts, where the statutory maximum is cut in half, and the sentencing guidelines follow suit by cutting the presumptive sentence in half. If it's merely an attempt rather than a completed crime, the mandatory minimum is not cut in half. The mandatory minimum is a full mandatory minimum, regardless of whether or not the offense was completed or merely attempted. Then we move into 1981. And again, this is the first switch where it went from all non-waivable before, or at least no waiver provision provided. For the first time now, everything is waivable. And there's a new tier for using a firearm, not just possessing it. And I see the logic here. You know, we had an equation of using a dangerous weapon and possessing a firearm that was brought forward from the 1974 statute. And now we're saying, well, what if instead of merely possessing a firearm, you use the firearm? Isn't that more serious still? And so in 1981, that's when the legislature said, yeah, let's make it more serious for that. So you've got the year and a day waivable first time, 3-year waivable if it's a repeat conviction for using a dangerous weapon or possessing a firearm. And now you have the second provision where if you use a firearm, it's 3-year waivable starting, and then 5-year if it's a repeat conviction. In 1989, we add drug crimes to the list. This is a big addition to the list because I think without too much imagination, it's pretty clear to see that the Subdivision 9 list was a violent crime list before the addition of the felony drug offenses. And not to say there aren't some felony drug offenses that are violent, but I don't think it's disputable that there are plenty of felony drug offenses that are not violent, at least in terms of the elements of the crime. So this is an interesting change. This change is 2 years after, so 1987 is the year that the legislature added felony drug offenses to the 624-712 violent crime list. And that's the list that we'll be talking about in a bit. That's the list if you're convicted under current law, if you're ever convicted of a violent crime on that list, and that's a much longer list, by the way, than the Subdivision 9 list. But if you're ever convicted of a violent crime on that list, you have a lifetime ban from ever possessing firearms or ammunition again. Um, and likewise, that's literally called a violent crime list. But you know, if you read through the list, it looks pretty violent until you get to felony drugs. All right, 1994, we have an interesting change, and I to me this is not necessarily a step up in terms of rationality. So in 1994, the firearm possession gets equated to firearm use. So you recall before there was an equation of firearm use, firearm possession, and other dangerous weapon use. Now we just changed it so that all dangerous weapons, other than firearms, are in one category, and possession and use of a firearm are in another category. So it doesn't matter, say when you're committing a kidnapping, whether you just have the gun on your person or whether you actually are using the gun in the course of the kidnapping. Either way, the mandatory minimum is in play. And instead of being all waivable, there's this non-waivability, depending on whether the defendant had previously been convicted of a listed crime in which the defendant possessed a firearm or other dangerous weapon. And so this is really if you took me up on my suggestion to read Table 2 from September's handout from the bottom to the top, just for kind of a rationality analysis, you'll find that it gets very confusing very quickly. You'll probably assume that I made a mistake in the table pretty close. You're like, that can't be right. But it is right. It doesn't make a lot of sense. And it's actually gotten a little more complex since then with the 2016 change. But that is the current system. That current system was introduced in 1994. A lot of strange things about, and I should say, it's not just non-waivability. There are also some strange things about whether it's considered a first-time offense or a repeat conviction. Namely that the prior has to be in the same category. So if you commit a crime number 1 while using a firearm, and then you commit crime number 2 while using a dangerous weapon, crime number 2 is still considered to be a first time crime, because you didn't commit the first crime with a dangerous weapon other than a firearm. You committed it with a firearm, which that's a head scratcher, to say the least. All right. So moving on to 1996, this is where we get ineligible firearms possession, and it gets its own it's added to the list, and it gets its own mandatory minimum penalty. And you know, this is we know this is significant in terms of the number of cases, right? We saw that last month on the chart, that this is now the most common. This is more common than every other provision in 60911 put together. That somebody would be possessing a firearm after a crime of violence conviction. And it had 2 tiers originally. It was 18 months waivable if first time, and 5-year non-waivable if there was a repeat conviction. In 1998, the penalty for first-time ineligible firearms possession gets much longer. So it goes from 18 months, to 5 years. But it is waivable unless there's a prior conviction. So, and let's see. That's pretty much it for major changes in 2015. There's an amendment to outlaw possessing a firearm or ammunition. So if you previously been convicted of a crime of violence as defined in 624-712, and you're walking down the street with a bullet in your pocket, in theory, the legislature wants you to go to prison for 5 years. And then in 2016, we have the drug changes, which has an additional, an additional column in the non-waivability chart there that I gave you last month. If the crime is a first or second degree drug sale and a defendant or accomplice possessed a firearm, then the mandatory minimum is not waivable. So here are my takeaways from this. What are some possible questions for research and study? And I'd be very curious to know what additions to this you all would have. So just in general, mandatory minimums, what is the purpose of mandatory minimums? And are they meeting that purpose, right? So two important questions. And I don't know how to study whether they're meeting the purpose until we figure out what the purpose is. What is the purpose of the waivability structure? And can we simplify it and I would say make it more rational? Because right now, and I think that's also true of the enhancement structure as well. Can that be made more rational? Should we, what's the purpose of having the different tiers and can we make that more rational? Should we treat people differently based on a prior record? Again, that's kind of the enhancement issue. Gun possession versus gun use. Should it make a difference whether the accomplice had the gun or the person being sentenced had the gun? Should it make a difference if the crime was merely an attempt? Or should attempts be treated the same as completed crimes? Then we get to the offense list, that offense of perhaps dangerous crimes. We don't really know. The legislature didn't spell out what the purpose of the offense list was, except kind of obliquely in other statutes. But what is the purpose of the offense list? Is it meeting that purpose? There's nothing inherently violent about drug crimes. Typically, they don't have an element of violence. There are some, first degree aggravated controlled substance crime has some elements of either gun possession or other, I guess, violent or quasi-violent elements to them, at least drug hierarchy elements to them. But typically the elements are, this is the amount of drugs you had and you were either possessing it or selling it. No real violence involved. Likewise, ineligible firearms possession does not imply violence at all. It's really a status crime. Sometime within, between the day you were born and today, you have been convicted of a crime on this list. And today you are possessing a firearm. Therefore you're guilty of this crime. It does not have to be violent at all. Is that okay? Is there a different way to deal with that? Like one thing, well, let's move on to the third column. For mandatory minimum purposes with ineligible possession, should the time from prior conviction matter? So again, this is the lifetime look back. I want to be clear here. So 624.713 is the statute that lists all the ways a person in Minnesota can be ineligible for possessing a firearm. Many of them are gross misdemeanors. There are a lot of ways to be ineligible from possessing a firearm in Minnesota that do not make you, do not implicate this felony and this 5-year mandatory minimum. But with respect to the felony, the one that implicates this 5-year mandatory minimum, should the time from prior conviction matter? Should the current circumstances matter, right? Should it matter whether, I think of this case I had where, this defendant who was kind of, maybe didn't have a stable living situation and essentially had all his goods in his arms, and was moving from, somebody's couch to somebody else's couch and walking in front of the Faribault police station, and encountered a Faribault police officer and dropped a gun out of his possessions. Certainly nothing inherently dangerous about that situation. And yet, based on his prior record, that would be a 5-year mandatory minimum. Should it matter if the prior offense was nonviolent like drugs, should that make a difference in terms of the mandatory minimum? And should it matter if it's ammunition versus a firearm? Should it matter if the firearm's loaded? These are the kind of questions I guess I have with respect to ineligible possession. And another thought I had is there's sort of a different way we could treat ineligible possession altogether, rather than treating it as its own mandatory minimum and putting an ineligible possession on the offense list. What if it were just to say, if you commit a crime on the offense list and you have a firearm, that the mandatory minimum or the penalty is somehow enhanced or stiffened if that possession of a firearm was ineligible because you had been previously convicted of a crime of violence as defined in 624. So those are just kind of some thoughts I had. I'm gonna stop just so I can see you all, and but I can put this back up if you like. And I'm curious to know what are some impressions people have from this sort of historical overview of mandatory minimums in Minnesota. Did anybody else get sort of the vibe that, like, I kind of saw where the legislature was going for a while, and then it seems like maybe they got lost a little bit, or does none of this ever made sense starting in 1974? I mean, was there a time where, oh yeah, I can kind of see where they were going there? Or any other comments that folks have?
Morgan here. I mean, it's a super interesting timeline. I mean, I guess I have a couple thoughts. Like, one is, it seems to me there's been this continuous sort of ratcheting up and adding on new things, but there really hasn't been a comprehensive review of like how we got here. And so that's one thought. And then the other thing that jumped out to me is the timing in which some of these big changes were made. So like the mid 90s was this time of perception of really high crime, and what we now call the myth of the super predator was driving a lot of the discussion at the time. And so I think we've learned a lot about some of the mistakes that were made in that time period. And I think we're at a spot now where we could correct some of the maybe expansion that happened.
Yeah, I would just add on to that, like the late 80s being the war on drugs, and that's when you saw the drugs get added to those two lists, so yeah, I see Dr. Stewart. So this is kind of ironic because I'm remote today. The people in person are at a disadvantage, so you're going to have to let me know if you have any questions. Dr. Stewart.
I found this really actually interesting because, I mean, and kind of building off the last point, I think that what strikes me is, as we're moving through, and I'm thinking, okay, what is the philosophy of punishment here? Like, what is the goal? What are the punitive interests of the state? And, I think one of the interesting things about Minnesota in particular, with the Sentencing Guidelines Commission's targeting original statute kind of like lays that out a little bit, like, here are some of our goals. But then some of these other things are coming up, and it's like it seems to me that these things are being done for purely retributive purposes. And if that's the case, I mean, I think it's hard for me to really. I think I really kind of want to go back to this idea of like, well, what are we hoping to accomplish here? What is this hoping to accomplish? Because without that, I think it's somewhat aimless. And I think, like the last point that was made about, maybe potentially correcting some of these mistakes, because, ultimately, like you say, if this is about for the ineligible possessions, if they're status offenses, then like, what are we even doing here? I mean, and if that's the goal, then that's the goal. But, like, I think we have to establish what that is. Because having this hierarchy of like the waivability piece, but then also the possession versus use, but then this differentiation between fire. I mean, it all seems very not organized. If that's the way to put
it. There is that, and it also makes it harder to use just as a practitioner. I mean, it's mistakes can be made pretty easily. Amber?
I mean, I agree with a lot of the questions that you have there, but also one thing that just stuck out to me both in as you were reviewing it, but then also just my experience is um starting when it comes to the predicate offense and whether or not it's listed in the 60911. I mean, that has deference to it too, whether or not a plea is made that puts you in that category or not. If you're originally charged with like a second degree, but then you go and plead to maybe a fifth degree assault for whatever reason, you aren't on that list if something were to happen again. Whereas another defendant who doesn't get the benefit of that deference from the prosecutor is on that list. And so there's it just seems like there's a, you know a when you have the predicate offense, there's kind of a I don't know. I think there can be a compounding effect for certain types of people, or maybe even certain jurisdictions that aren't the same in other jurisdictions or other types of people. And that's just something that I think is interesting because sometimes you have that, you're stuck against the wall, whereas other defendants who might have the same criminal history in the original charging aren't, if they are found like have a gun possession or commit another offense that falls under 60911. And one thing that I was thinking about is the recidivism rate for people who are subject to mandatory minimums and get that sentence, and then those who get the deference, especially when there is the waiver attached, and whether or not that makes a difference as to how, especially for the first time that they're subject to it, whether or not that would make a difference in their recidivism rate going forward in life. And I don't know if historically if there's anything that could be figured out about that too, but I was just thinking about how there's a compounding effect here that seems to keep being built on whether it's drug offenses or just simple possession. That was my thought.
Yeah, I have several sort of responses to that. One is I think, I mean, really, why do we punish people? It's probably because we either think they're dangerous or because, there's something really bad about what they did and we just want to punish them, sort of retributive. And we can measure dangerousness. That's something that we should be able to analyze. Are we going after the right people here?
Well,
The other thing I think it's probably important to mention that you brought up, Amber, is the sort of how this works mechanically. How do these how do we get to 60911, right? How does this get invoked? Does somebody have to stand up on a stool and say I invoke 60911? And the way it gets invoked is one of two ways. Either the crime itself, the listed offense on 60911 has subdivision 9, that crime itself has an element of dangerous weapon use or possession of a firearm or use of a firearm. And that's one way to get there. And if it is one of those crimes that has that, then the sentencing worksheet will say, hey, this has to go to prison, because like second degree assault, for example, second degree assault is assault with a dangerous weapon. So by definition, a dangerous weapon was used in the course of the assault. Now we don't necessarily know whether that was a firearm or an other dangerous weapon, but we know there was a dangerous weapon of some sort involved. So the sentencing worksheet is always going to say this is a presumptive commit because there's at least that year and a day mandatory minimum going on here. But not all offenses have an element of use or possession of a dangerous weapon. So for those offenses that do not have that element, which is most of the offenses on the list, the prosecutor is going to have to allege and prove the fact that there was a dangerous weapon used or a firearm possessed during the course of this crime. And maybe everybody knew that, but I just thought I'd point that out. That again, that's another thing where sort of the prosecutor has the keys to just even open up this book on mandatory minimums. And other comments? Oh, yes, I see
Yeah.
that hand.
John Donovan, I just more of an observation. I've never really looked at the statute sort of historically as it was presented here, but piggybacking a little bit off of what Morgan said, it does feel sort of reactive, like I think another statute we're going to look at, not as in depth, but the registration statute. As time goes by, going, oh, also this offense. Oh, also this offense. Oh, also register this. Oh, also tell us this. And it does feel like, okay, something happened and someone got in maybe someone's ear. And now we want to start including that too. And it gets so big and you have to sort of step back now and say, well, what is the purpose of all this? Why all this? Has it gotten too broad? So.
That kind of brings me back to sort of the idea of, I'm sure I've read this somewhere, and doing as an agency director and having to do all these internal controls. One of the principles of good governance is an iterative policy review. You shouldn't just put a policy out there and just let it hang out there forever without from time to time going back and looking at it and saying, does this policy still work? Does it still meet its intended purposes? Are its intended purposes still valid? These are all important and good questions that every model of good governance should do. But it's not something that's necessarily built in automatically into the legislative process. So I think that's why it's important for us as a task force to exist. And I think it's important for us to kind of take our mandate seriously and really scratch deep onto these questions and see if we can figure some of this out. Because I think it's really a good thing that this is being asked. All right, I'm not hearing or seeing any other comments. Yeah, Rob, and I guess maybe I have a question more for the committee chairs, but is there anything about this conversation that we've been having that inspires you to do some exploration in your particular area?
Yes. I guess the question for me is how deep we would want to go, and maybe that's something for the kind of data subcommittee to talk about. I mean, this question about the addition of the ineligible possession thing, 1996 to 1998 or whenever, when that was, and then when it was raised up. I mean, it's giving me a lot of ideas about potential like quasi-experimental statistical analyses that could be done. Now it depends on whether or not, comparing people right before and right after type of thing. But it also depends quite a bit on what data are available. I know we'd have the guidelines, but not necessarily the court data going back that far. So for anybody who wants to have a good time and talk about this stuff ad nauseum, come join the data committee. Oh, one other thing. This got me thinking as well about, for Kelly's group to think about. I mean, I think there was conversation about talking to the courtroom worker or like attorneys and judges and other people, but I'd also be really interested to hear about law enforcement perspectives when it comes to some of these differentiations between like ineligible possession versus possession or use in a crime, that type of thing. Because I just, I'm not sure we always actually, end up hearing that perspective, but I'd be really interested to hear about the people who actually work on those cases, day to day.
Yeah, and thank you for bringing up ineligible possession, because that's kind of a question I have for the whole group about the scope of we were talking about scope at the beginning, and I kind of want to bring that up again because the largest slice of the pie, as we saw last month, was ineligible possession of a firearm, and particularly the felony version of that for having previously been convicted of a crime of violence. And my temptation is to say, well, look, if that's going to be a mandatory minimum offense, then isn't it within our scope then to sort of analyze the elements of that crime as well? So kind of moving beyond 6911, but moving to chapter 624 and saying, is the crime of violence list correct, and is the structure of the statute correct? For example, it's a gross misdemeanor, I believe, to you can't possess a firearm if you're a drug addict, right? And that's a gross misdemeanor to do so. But if you're ever convicted of basically being a drug addict, if you have a prior drug conviction on your record, that's a lifetime ban, and it's a 5-year mandatory minimum. Would it make sense to maybe move the drug penalty provision, the drug, prior drug conviction part over into the gross misdemeanor section rather than keep it on the crime of violence list and that sort of thing? Now, I don't know what the task force thinks about that. Is that outside the scope of our mandate, or is that well within our scope of our mandate? Because look, this is the most common mandatory minimum provision, so is that making sense to folks? Do people feel like that's within or without the scope of our mandate?
I personally think it has to be within these things are all intertwined, and we need to be able to understand how they're working together and whether they even make sense and achieve the goals that the legislature intended.
And not to get ahead of ourselves, but I see sort of a similar issue with respect to the predatory offender mandatory minimum. I mean, it may be that there's a way of committing that crime that should have a mandatory minimum, but maybe the statute just isn't written that way yet. You know what I mean? Like maybe there are circumstances, if you do it this way, or you do it around children, or you do, whatever it is, if you do it under these circumstances, yeah, you should be going to prison. But like to say that every single violation of this, really long law, a really long list of requirements, any violation, any intentional violation of those requirements should send you to prison. Maybe there's a different way to do that. So, okay. Well, I'm gonna assume 624 is in scope then. The 624, 712, and 713 is within the scope of the mandatory minimum. All right. Well, that if there's no other discussion on that point, then I'm going to turn the microphone over to Professor Osler, who's going to give us a look at the philosophy and reasoning behind mandatory minimum sentences in general.
Yeah, and look at the history a little bit. So Nate, you might want to mute because we've been getting some backwash. Thanks. Yeah, and thinking about this, when we look at the colonial era and the early republic, one thing to keep in mind is, John was talking about how with life imprisonment without the possibility of parole, it's a maximum and a minimum. But we're talking about laws that came out of a world that basically didn't have prisons. And that means that for most punishments that were given out at that time, there was just one option. It was going to be death. It was going to be exile. That if a certain crime was committed, the person would be given a humiliation punishment. I mean, I went to college in Williamsburg, Virginia, where the stocks were there on the main street, which was the punishment for some crimes, is that someone was to be held in the stocks for a day. So you didn't have the option of various periods of incarceration because there's no place to imprison people. And so a lot of the ideas behind mandatory minimums we see developing consciously much later rather than early in the Republic, because at that time they didn't have the options that we do in terms of picking a range, for example, for incarceration. We don't really see that until the 20th century. And, you know, it's interesting. I mean, the original mandatory minimum is, you know, the death penalty, that in early societies, that was the penalty that was available. And you had the death penalty available for a wide variety of things. And in 1790, when Congress really passed the first version of the penal code, 7 of the 23 federal crimes were mandatory death penalty. And so, and we saw that echoed in the states as well, that mandatory minimums basically were establishing what the penalty would be, and often it was the death penalty. In terms of understanding the philosophy behind mandatory minimums, even though that death penalty history isn't analogous in some ways to what we're dealing with, some of the philosophy behind it really is. And it's interesting to look at the way we finally got rid of mandatory death penalty statutes. In 1972, the Supreme Court strikes down the death penalty in the United States in Furman versus Georgia. And then it comes back in 1976. And there were 2 different models that states had for bringing the death penalty back, because it had been struck down. The plurality was that it was too arbitrary, the way that it was being imposed. So Georgia and Texas came back with schemes that limited the number of people who were eligible for it. In other words, they took the circle of eligibility and shrunk it. But North Carolina did a different thing. And they said, okay, for certain crimes, the death penalty will be mandatory. And so they're going back to a mandatory death penalty structure. And their basis for that was that this is going to create deterrence. This is going to be truth in sentencing, and this is going to be a certain punishment that addresses the Supreme Court's concerns in Furman. And that arbitrary nature of it is part of what led to the mandatory minimums later that I'll talk about. It's the same set of concerns, really. But in Woodson, what the Supreme Court concluded was that the value of individualized consideration, that everybody had to be considered on their own merits, meant that that a mandatory death penalty was going to be unconstitutional. And that dichotomy, that push-pull, is behind a lot of what we see when we see mandatory minimums discussed. It's between uniformity on one pole, that everybody's going to get the same sentence, which is viewed as fair. And on the other sense, we've got individualized consideration that goes with judicial discretion. And what happens over time, and when you look at any of these examples of a mandatory sentence, whether it's the death penalty or you know the lesser mandatories we're talking about, is that you've got the goal of uniformity, you've got a mandatory minimum that's established, and it over time is undermined by discretion of prosecutors and judges. And we've seen that with our mandatory minimums too, with people charging around it, and with the waivability provisions that have been built in, and the disparities that result from that. You know, that the mandatory minimums as opposed to the mandatories, you know, they're more mandatory in some places than others. And that's been true in a lot of places. So in the late 20th century, you had a lot of discussion about mandatory minimums. And part of it came from the states, that in 1973, New York State passed the Rockefeller drug laws. And the Rockefeller drug laws were incredibly harsh. They established mandatory minimums for simple possession of marijuana, leading to imprisonment, for example. And the thing about New York, and this is true of the federal system too, where you've seen a lot of harsh mandatory minimums come up, is that it's a place that within that state, there's incredible disparities in sentencing, because they've got one huge city, New York City, where sentences were much, much lighter than in upstate New York and the rest in the suburbs and in Long Island. And people looked at this and thought, oh, wow, you're getting, you know, probation in one place and 20 years in another place for the same crime. And we need to address that. And the same problem was starting to be observed in the federal system too. And there it's a different dynamic, which is that you've got judges who have lifetime tenure, or are going to be there forever, who are appointed by very different presidents and are going to have very different outlooks. That, when I was a federal prosecutor, I was dealing with Reagan appointees who were next door to Carter appointees. And they had incredibly disparate outcomes in what they wanted to do with sentencing. And so in the federal system, you had that dynamic driving the disparities. Now with the Rockefeller drug laws, it's interesting because this is something we're going to be dealing with. A lot of the basis for it was that there was seen to be a correlation and causation between narcotics and an increase in crime. And that's something that you see over and over, is that there's a nexus between drugs and gun violence. In many cases, that's true. I mean, it's not wrong overall, but it's situational. And so it's going to vary from one type of drug and one situation to another. Now, the thing that mattered about when New York and later Michigan imposed these really harsh mandatory minimums is that what was really driving crime more than anything was demographics. That you had the baby boomers in their crime-prone years. I mean, we all know that people between 15 and 24 commit proportionally many more crimes, violent crimes, than other groups. And when you've got a demographic egg in the snake, like they had with the baby boomers, all being that age at the same time that recreational drugs are being more available, a lot's going to happen. And there was an increase in crime. There was an increase in drug use that happened at the same time. Those two things were correlated, but the causation wasn't very clearly shown. And, it didn't work. That crime didn't go down. It went up in New York State after that, even though their prison population went up 600% in 20 years. So they really built a bunch of prisons, overfilled the ones they did have, and it was repealed eventually in parts, but mostly in 2009. And even at that point, when it was pretty much judged by all to be a failure, there was resistance from prosecutors because of the leverage that they gave them in seeking plea agreements. Michigan's primary mandatory minimum was a life sentence for 650 grams of cocaine or heroin. And that came in 1978. It was repealed in 1998. And interestingly, in both New York and Michigan, the people who pushed to undo the laws were the same people who had pushed for them in the first place. For example, Governor William Milliken in Michigan, who signed the harsh law into existence, was also one of the primary advocates to end it much later. So we had a couple things going on. One was that Congress had issued some pretty harsh narcotics laws in the 60s, but repealed many of them in 1970. And then stuff really rolled in the 80s. And that's where we see a lot of the mandatory minimums coming from. And when we see, here we see narcotics added to what's going to be in the list of what's going to make you eligible for the mandatory minimums. In the federal system, you saw the Bail Reform Act that got rid of bail. They got rid of parole. They created mandatory guidelines. The 100-to-1 ratio between crack and powder was imposed. And there was a whole raft of mandatory minimums that were passed, particularly with narcotics, but also with guns that were related to narcotics trafficking. Now, the thing about it is that the context of that was the rise of crack. And with crack, there really was causation between drugs and guns, that it was observable that the guns and the gun violence correlated to that particular type of drug trafficking. But it's important to recognize something about crack, and to a lesser degree, meth at that time, which is that there was extremely low barriers to entry to get into that business. All you need, I mean, make crack, all you need is some cocaine, some baking powder, and some water and a stove, which means that everybody could be a drug dealer, basically. And that meant the competition on the street was it was brutal capitalism that led to a lot of gun violence, that people were making money, then someone moving on their turf because they could make crack real easily, and you got gun violence that associated with that. When I talked about meth, I mean, some of us remember the days when most of the meth that we saw was stuff that people were cooking at home using Sudafed. But then they pulled Sudafed behind the counter, and we started to see it much more in pill form, and the violence went down that was associated with it when it had that much lower barrier to entry. We don't see gun violence affiliated that much with drugs like ecstasy, for example, that has a high barrier of entry to get into in terms of creating it and wholesaling it. With fentanyl, fentanyl has a relatively high barrier to entry. And interestingly, here in 22 and 23, as we saw fentanyl use skyrocket, violent crime was going down. And so that correlation wasn't even there between drugs and guns during that period. I want to talk a little bit about, in the 1980s, when we saw so many of these, in the 1970s, when we saw so many of these mandatory minimums being created, what the basis was for it. And what we saw being argued at that time, basically, in addition to in the mandatory minimums that went to drugs and guns equal gun violence, that was sometimes true, that you basically had 6 bases that people put forth for the mandatory minimums. First, deterrence, that if people knew that they were going to get a certain sentence, that they would not choose that particular crime. A second was that it would prevent crimes associated with narcotics, which would include the gun violence, but other crimes as well. The third was a real belief in retribution. That is, that these are crimes that are morally wrong. And I mean, I remember as a drug prosecutor myself talking about people poisoning their community. And that is really a retribution argument that's being made. The fourth is something I've talked about before, which is uniformity, that people pointed to the way judges were treating the same crime very differently in one place than another, or between different judges. And that a way to even off those disparities was to have the sentence be mandatory. Now, one of the things that we see is that mandatory minimums were often put forward as a way to address racial disparities. That even with the crack mandatories, that there was the argument made that we've got racial disparities that if we have a mandatory minimum sentence, would even that out. Now, that didn't prove true over time. A fifth is truth in sentencing, which is related to deterrence and some of these other things, but was seen as having its own value, which is that there was an honesty to what the price was going to be. And we saw that informing the movement behind mandatory minimums as well, which is a related set of factors. And then there was a last thing that it's close to truth in sentencing and the uniformity, but a little more specific, that in many places you saw the argument about the bad judge, that there would be one judge that just wouldn't put anybody in prison for a particular crime. And sometimes that uniformity argument became pretty personal. Now, the contra arguments over time that emerged, one was that the mandatory minimums didn't work, that there was no way, there wasn't a result that would justify the harshness of the resulting sentences. We saw that with crack. Crack didn't go away while those harsh sentences were being imposed. It actually faded later once those were being used a lot less frequently. Another contra argument has always been individualization and judicial discretion, that we need to be able to trust judges to distinguish between cases, and that there's going to be factors that aren't taken into account with mandatory minimums that really merit consideration as a basis for the ultimate sentence. And finally, one of the things that came up over time that's been the basis of a critique for mandatory minimums is how they drive upside down cases. Particularly in situations where a prosecutor has the control of whether or not a mandatory minimum will be imposed, which is true in the federal system with the drug cases, that the really harsh mandatory minimums in 21 USC 841B are triggered by the prosecutor noticing it up. And when I talk about an upside down case, what would happen is that you'd have a drug conspiracy. Everybody was charged with the same amount in an attempt to convict the most culpable person. The prosecutors would threaten a much less culpable person with the mandatory minimum. Say, we're going to notice you up if you don't testify against the ringleader, and you'll have life in prison. And the person would say no. And so at that point, you've made a promise about what you're going to seek. You lose credibility if you don't follow through. And that lesser person would get the higher sentence, whereas the kingpin may get a good plea. And those upside down cases really drove a lot of the criticism of particularly those narcotics mandatory minimums. I think too, in terms of political dynamics, that there is generally prosecutors are for them, defense attorneys are against them. If in terms of political actors, they have an appeal because they can show that we're taking a particular crime seriously. I mean, for example, with crack, there really was a problem. It did drive violence on the streets. It did have a terrible impact on communities in Detroit, just through the use and the patterns of use. And so it wasn't wrong that was a serious problem that needed to be addressed. Now, judges historically have opposed mandatory sentences because it takes away from their discretion. But there's a lot of nuance there in terms of, judges are often reluctant to enter the political sphere to support or reject a new initiative. And, often it's retired judges who are most vocal about those things. So, one of the things that I'm hoping to do, Nate, having looked at the history that you presented, is to look at the legislative history of when they added the narcotics crimes as the basis for the mandatory minimums. What were their arguments being made there? My hunch is that what I'm going to find is exactly what I'm talking about in terms of, the nexus to violence, the uniformity and things like that. So, questions?
This isn't really a question, but it's something that I was thinking about as you were presenting, Professor, and this is Morgan Coons, is this idea of deterrence. And, I do wonder, does a large sentence have a deterrent effect versus an assurance of being caught creating the deterrent effect? Because for a large sentence to have a deterrent effect, people have to know about it and they have to think that they're going to be caught by it. And I don't know that there's a lot of awareness out there about it. And I certainly think that people don't think they're going to get caught in some cases. So I think that would be interesting from a research perspective and also from a data perspective, if there's any way to get at that question.
Yeah, and there's been a lot of research on that. Well, caveat on when we talk about deterrence is that it's very hard to measure because you'd have to have people describe why they didn't do something, which means you have to find the people who didn't do it. And that's very difficult. Most of the serious studies that have looked at this, and I'm sure Rob Stewart knows all about this, but have concluded that the likelihood of being caught has a much higher chance of deterring someone than the potential sentence. One thing I would note is that when we talk about deterrence, two things have to be true to deter somebody. One, they have to know about the potential sanction. And two, they have to be making a rational cost benefit analysis. And we, for example, think about the death penalty. In Texas, often the argument when I lived there for 10 years, and the argument you heard for the death penalty was, well, if people will not commit a murder if they know that the death penalty is on the table. But the problem with that is that the two guys at the gas station who impulsively kill the clerk, they're not making a rational cost benefit analysis in that moment. One of the ironies is that if we really cared about deterrence, we would use it for people who really do make cost benefit analyses, and that's white collar criminals. If we were thinking, okay, we want to target people who think things through and are avoidant, then it would be those people who are educated in making cost benefit analyses. And we've seen deterrence measures work against them. I mean, one of the things about Rudy Giuliani when he was U.S. Attorney in New York was that he took deterrence seriously. And one of the things he did is that if there was an insider trader, when they indicted that person and got the arrest warrant, they would do the arrest not at 6 o'clock in the morning at the person's home. They would go to their place of work at 3 o'clock. And the marshals would bring a TV crew and they would walk in past the secretaries and past the analysts and past the vice presidents and then arrest the guy and perp walk him back, and it would be on the news. And that did deter people who were, other executives who were making those cost benefit analyses.
One thing I'd say about deterrence too is if deterrence can work, it has to be understandable. I mean, just some of the, I'm thinking particularly about table 2 and that complex system of waivability and non-waivability. If the purpose of having it non-waivable is to say, oh, you're for sure going to go to prison if you do this, then it'd be probably helpful if it were a little more understandable.
Yeah, and I can tell you as a teacher, Nate, if you could mute. Yeah, thanks. As a teacher, explaining mandatories and mandatories to 26-year-old third-year law students is hard enough. That I can't believe that people on the street have an innate understanding of that.
There's like a general concept within the research or kind of punishment theory where deterrence is effective if it, swiftness, certainty, and severity, right? So if you know it's going to happen, it's going to happen quick, and it's going to be a big deal or it's going to be severe, then they tend to be more effective, right? And so, I mean, I haven't looked at the data, but, thinking like, for example, Minnesota making the 4th DWI a felony back in 2001 or 2 or whenever that was, those types of things can be more effective. But when it comes to some of this other stuff, especially the, like waivable mandatories, well, okay, so then what is it actually? And then all of those things can come into play. But I would say that there is potential for some of these things that we could, potentially measure or at least estimate. Obviously, you can't measure things that don't happen, but you can, like do cohort comparisons of groups before and after laws go into effect, like with the ineligible possession and some of those types of things. Of course, if the data exist.
Other comments or questions on Professor Osler's presentation? All right. Well, very good. Thank you, Professor Asser. That was really interesting. The we're up to other business. Don, do you have anything about vacancies for us? Any updates?
I unfortunately put this on here, but there is not any movement yet on any of the vacancies. We still have 3 vacancies. And I'm reaching out weekly to the organizations, trying to push them to get that. If there is any change, I'll let you know.
Okay, sounds good. And is there any? Can you remind us of those organizations again, just in case anybody on the task force has particular pull in any of those areas?
Yes, give me just 1 second. The peace officer, it's a peace officer familiar with a shooting investigation appointed by the Minnesota Chief of Police Association. A member of a statewide civil rights organization appointed by the Speaker of the House of Representatives, and a retired district court judge appointed by the Chief Justice.
Okay, thank you. All right, so this meeting is on WebEx, so that means it's recordable. Don, I don't know if you are recording it.
I am recording it, yes.
Yep, I see the little red dot there. So that means that it can be made into a video and posted on a hypothetical YouTube site. I don't know if DOC has a YouTube site that would be usable for that purpose, but
the DOC does have a YouTube site. I can work with our communications if that's what you'd like. And we can have this posted on YouTube. I could also check to see if we could just post it on our website.
oh, sure. Yeah, and certainly link the YouTube. If it does get posted on YouTube, we can always put a link on our website to the video. But and the reason I'm asking this is we had some interest in watching last month's meeting, and we hadn't really discussed posting the meetings on YouTube. Is there anybody who would object to posting the meetings on YouTube? That's not a or the equivalent. That's not a requirement of the open meeting law by any stretch, but it certainly is good for transparency, or anybody else who's trying to figure out what happened with the great train wreck of 2026 with the task force. No, I mean, whatever ends up happening as a result of this, it's good for historical purposes, I think, to have the video out there. But is there anybody who would object to putting this out on YouTube? Okay. Well, I think that'll be appreciated by others. I know we've been doing that on the Sentencing Guidelines Commission for a while, and we've had expressions of gratitude from various quarters for doing that. It'll also help, I think, as we do fill those vacancies, help other people who might be interested in catching up. I've said before, I sound much more intelligent at double speed. If anybody's watching it on YouTube, just go ahead and flip that counter to double. All right. So let's go ahead and do that, Don, since there's no objection. Any other business?
We do have members from the Wilder Foundation if they have anything. Nope, not yet. Okay, sorry.
Okay, still just in the fly on the wall stage. And
Yeah.
okay. And let's see, any members of the public? I see it looks like Julia Laskrowski's online. Any members of the public, either online? I suppose, Julia, you could raise your hand. I assume does she have yeah, it looks like she has. maybe chat permissions too. So Julie, let us know if you want to make a comment. Otherwise, any other members of the public who are there in the room, and I don't know if there are any such. Oh, Julia has nothing. Good. Thank you, Julia. And any members of the public in the room? Okay. So no public comment. Moving along. So the next meeting then is Friday, November 14th. So got a few months. So in between, I would hope that the subcommittee chairs, I'd like to organize the subcommittees within the next week. I hate moving forward like this without the full complement of our membership, but we also have a limited amount of time. So, we're down to less 9 months or so to finish up here. So we do need to move along. So I appreciate if the subcommittees, if Don, if you could get out the poll on who wants to be on what subcommittee, and then I'm thinking maybe we could have a meeting of the chair, vice chair, subcommittee chairs, and Don, and sort of make final decisions. Again, please make it a ranked choice poll, Don, so people know. So we can, if one of the subcommittees gets too large, we can divvy it up that way. And then subcommittee chairs, if you could think about meeting, having a good meeting between now and the next meeting, and not too close to the next meeting. So you and then report at the next meeting. That'd be great. Anybody see any issues with that? Okay. Well, I think that takes us to the end of our business. So we're at a schedule. Nobody got any other business to speak about. So unless there's an objection, we'll adjourn. Is there an objection to adjournment? Right, hearing none, we are adjourned. Thank you, everybody.